we are here today just to hear one case, the Detroit Caucus versus the Independent Citizens Redistricting Commission. As you know, we have given you each 30 minutes. We will let you start and give you about 5 minutes of uninterrupted time before we start asking questions. Mr. Ayad, if you would like to reserve time, you may do that, but we like you to try and keep track of it yourself. And if you are ready, you may proceed.
Thank you, Chief Justice. Justice, good morning, and thank you all for hearing this case. Chief Justice, I would take 20 minutes on initial arguments and leave 10 for rebuttal, please. And I know Mr. Royster said I'll keep my time. I'll keep track of my time here. So to begin with, I would really like to very quickly recognize my co-counsel on this matter, Tanisha Yancey and Mr. William Savage, that worked so hard, as well as our expert, Edward Sarpolis, that has been volunteering his time for quite some time. So I really appreciate his time. Justices, on November 18, the amendment to our state constitution of 1963, Article 4, Section 6, created the Michigan Independent Citizens Commission, as you all know. The commission was tasked in adopting a plan for the U.S. congressional, state, senate, and house maps. Under Section 613A, mandated that the districts must be of equal population as mandated by the U.S. Constitution and shall comply with the Voter Rights Act and federal laws. And subsection C, the district shall reflect the state diverse and communities of interest. Communities of interest may include, but shall not be limited to, populations that share cultural, historical characteristics, or economic interests. A community of interest has been defined by the leading case of Thornberg versus Jingles, whereby our U.S. Supreme Court laid out 3 criteria outlined in its holdings: sufficiently large and geographical compacted districts, 2, sufficiently cohesive, and 3, tends to vote differently than their majority opposition. Michigan even uses a much broader definition of communities of interest, where only needed is to show cultural or historical characteristics or economical interests. The Voter Rights Act was enacted to prohibit this racial discrimination in voting. The act will be amended 5 times to assure its effectiveness. Section 2, amended in 1982 in response to the city of Mobile versus Bolden, and made clear that plaintiffs need not prove discriminatory intent or state government to challenges in elections. The importance, Justice, is the obvious that plaintiffs need only prove the discriminatory result as opposed to the intent or the motive. Simply put, if the results discriminate, in other words, dilute the community of interest, here being the African American community, that is all that is needed. The Thornberg versus Jingles Supreme Court holding laid out a party must establish in meeting out the dilution of the community interesting voting powers. To begin, it is undisputed between plaintiffs and defendants that the Thornberg versus Jingles case controls, as both parties have argued for and in accordance to its analysis, both in plaintiffs' briefs and in defendants' response. In Jingles, the Supreme Court laid out 3 factors to this court must undertake. 1 is the minority group is sufficiently large and geographically compact to constitute a majority in a single member district. 2, that the minority group is politically cohesive. 3, that the majority votes sufficiently as a bloc to enable it to defeat the minority's preferred candidates. As to number 1, the Black community is sufficiently large and geographically compact to constitute a majority in a single member district. The 2020 census tells us this by the vast number in cities such as Detroit, Pontiac, Flint, Inkster, and others. For instance, in Detroit, in its geographical boundaries, Blacks make up 79.1% of the population. Although this litigation is not only for Detroit, but Detroit is being used as a prime example on the effect of the proposed redistricting maps, where Detroit has had 10 House districts and 5 Senate districts in and around the city that were majorly impacted more than any region in the state. 2, the Black community is politically cohesive. Despite the defendant's position, the Black community does vote in a cohesive fashion for their candidates. This is an important distinction, as the defense would have you believe that because their Black candidates may not have won the general election, that somehow the Black majority districts do not have a cohesively vote for their candidate. The problem with this line of reasoning is that the Black community oftentimes has multiple candidates running. Wherefore, the votes get split in a number of ways for the multiple candidates, thereby leaving the white counterpart with the majority to be all the Black candidates by a simple minority support of that district. The commission defendants wrongfully argues that the Black community has no preferred Black candidates, simply because the commission's expert looked simply at the results of the general elections. It failed to consider that failed to consider that the Black candidates preferred overwhelmingly the Black voters by the Black voters didn't win, not because the sheer number of the Black candidates running. To have their expert opine that because the Black candidate doesn't win, that somehow, some way, there's a crossover voting for the white candidate is simply without merit. The Supreme Court doesn't speak as to one preferred candidate, but uses plurality in speaking as to the preferred candidates. And this could be found in Jingles at page 31. Also, again, if there is, for instance, 80% majority Black in a region and a district, and you have 8 African Americans running and they split it evenly, you're going to have each sharing 10% of the vote. Where if you have one candidate that is white and running that has a minority interest of 20%, the white candidate will prevail since it had the majority of the primaries because the African Americans split it. And their expert would have you believe, well, look at the general elections. The African Americans are voting for the white candidate. That's not necessarily true. They've been voting for the Black candidate. When they can't get the candidate they want to stick with political party lines and end up voting for that white individual that won the primaries. And therefore, it seems as if they're voting for the white candidate and the crossovers intact, but that is far from the truth.
Mr. Ayad, let me interrupt you now and just make sure we get to questions, and then we'll get back to you if there's more time, okay?
Yes, ma'am.
Thank you. Justice Zara.
Thank you very much. The Supreme Court of the United States has made it very clear that the burden to prove that redistricting maps violate the Voting Rights Act on the basis of race-based decision-making, quote, lies with the challenger, not the state, end quote. The commission says you simply haven't provided any alternative plans, so we can't even start this analysis. And if we can't start it, it ends here. So please take me through with as much detail as possible what you believe you need to do to meet your burden and how you would meet it. And if anything, if anything do you need to get to that point? Or are you satisfied that simply what you presented to us is sufficient for us to make a ruling in your favor?
Well, Justice, thank you for that question. Well, it is an important question, but in all sincerity, we did supplement. We showed a few examples initially in our complaint and brief. Then we supplemented in our reply. We indicated a number of candidates with clear examples, such as Betty Jean Alexander versus David Knesiak, Santana versus Gary Warnchuk, Abraham Ayers versus Adam Hollier, the election of Mary Kavanaugh, all to show to the point of our position that how that breakdown works. Now, obviously, we don't have the tax dollars that the opposing party has and the hundreds of hours of experts to put in hundreds and hundreds of pages of expert testimony in a short period of time. But I can tell you, Justice, that from what we see and from what we presented and what the end result is, and that is actually what Section 2 exactly calls for, is that you have 2 U.S. congressional districts, majority and minority African Americans that have been dwindled to 0. You have 4, some depending which numbers you're looking at, 5 state senators that have been dwindled from 5 to 0, majority minority districts. You have 12 House representatives that have been dwindled from majority and minority districts to 6. I think that is clear evidence in of itself, Justice. That's one. But more importantly, if you look at the numbers these individuals are winning, they're barely winning, even the ones that do win in the majority minority districts. How in the world are they going to win at a 35% majority that's been stricken down? If you look at the numbers have been reduced on average from the Michigan Senate, the African-American vote has substantially dropped in their districts. The African-American numbers have dropped, but the new mapping district, 18.7% for the Senate, 23% for the House of Representatives, the average decline in the Black population in those districts. So it's almost going to be impossible for these African-American candidates to win with the constituents, for the constituents' vote.
Are you taking the position that you do not have to present alternative plans?
We did present an alternative plan. We did present some maps in our reply, Justice. We did do that, and that was, again, a matter of hours. These individuals, again, we have to be mindful that these maps have, these majority minority districts have been around for decades. It's not as if we are starting from scratch. They're intact. Majority minority, even their own expert says that you must leave intact the majority minority districts there in place. Our expert says the same thing. If the court wishes to dive into further with additional, or even an expert appointed by this honorable court, I think would not be also a bad idea, to show that indeed African Americans are getting the very short end of the stick. And the question is, why should the African American be the sacrificial lamb in this state redistricting map? It's not fair, it's unjust. And for the 70 years that the African Americans have fought for civil rights to gain their power in these districts and be just nodded away with the strike of a pen within a making of the map in 3 weeks, really. If you have, the expert received the information on August 12th from the U.S. Census Bureau. Her report to the commission was on September 2nd, 2021. Within 3 weeks, she basically made these findings, even though they said they didn't have all the data that was necessary to this honorable court. So there's a lot of challenges with the redistricting maps that have been proposed, Justice.
I do have other questions, but I suspect my colleagues do as well. So I'm going to pass for now. And if there's more time at the end, I might come back to you. Thank you so much.
Thank you, Justice.
Thank you. Justice Viviano.
Thank you. Just to follow up briefly on what Justice Zara said, your expert affidavit that was submitted was pretty conclusory. And so is it your position that you can prevail without providing further expert analysis? In other words, based on your submissions to date?
Well, that depends on the justices if they feel that more information is necessary. Again, it's nice and fancy that they had an extensive report committed that was done over months and months in time. We don't have that luxury, Justice. What they presented, and again, based on fallacies, in my opinion, that sounded great, and in fact, when you look deeper, that's not basically what's going on at the end results. So, would we like some more time that we could beef up even more expert numbers and what have you? Sure, we will always take that. But I think the numbers speak for themselves. Again, we're not looking at the intent. We're not looking at motive. This is not an equal protection violation claim. This is a Voter Rights Act Section 2. And the end result, the importance of obviously that is that look at the results. The results speak for themselves, Justice. Again, just because they have, again, other numbers, which again, we showed how their numbers are not accurate or not proper because of what they're looking at is this crossover idea and this racial polarizing, which we've showed on from vote over vote, and it's a lot of, in at least in the how should I say, in the political world, it's common sense who votes for what. And I say to you that we have enough that's been substantiated and submitted to you to show the end result that there's discriminatory and dilution going on in the African American community districts.
Yeah, I understand the time has been short for you and your clients to provide and prepare the materials that are required, in part because the commission didn't comply with the deadline in the Constitution, and they submitted their maps several weeks after that deadline. But this court is not often called upon to sit as a court of original jurisdiction, and I think we're trying to determine what the procedural posture of the case is, and and whether the case is ripe for adjudication today or whether it needs further factual development. And so I appreciate your difficulty with resources, but it's not, as when I sat as a trial judge, I guess I'm not really familiar with the response of, we don't have enough resources, but if the court wants to appoint somebody to do our work, we'd be happy to have that. Is that what you're saying your position is?
That's not, with all the respect, Justice, what I'm saying. What I'm saying is that the evidence is clear as day to us and what was submitted thus far. Just because someone adds additional pages on their belief and why their numbers are right should not be weighted against. It's not so much the number of pages, but the substance of the what's in those documents. We've submitted clear examples. I mean, clear examples from state, House, presidential election results where the African American votes for the African American candidates and the white counterpart votes for the white counterpart. And the numbers and the results show again that they were already having a challenge and being elected because many of the difficulties and the totality of circumstances, whether it be education, finance, housing, redlining, whatever the case may be, transportation, that the challenges with the African American community is to even get a vote in, even at 50%. Some say you need at least 5 or 10 or 15% higher to even make it a fair play for the African American to vote. So I'm not saying we are not ready, Justice. We are ready. I feel that there is enough information there to place. But if the justices would like some additional information, we'll be happy to provide that to you. I think procedural-wise, you're absolutely correct. It cuts down on our time in presenting our case.
Let me just jump in. The question is that we're trying to figure out is whether you can establish your case without the aid of expert analysis. With all due respect to the expert that you referenced, I don't think we've seen any analysis by that expert or any others that would rebut what the expert analysis we're getting from the commission. And so the question is, the first order question is, do you believe we can decide the case in your favor without further expert analysis?
Well, I mean, if you're not going to consider our expert, Justice, I would say not to
it's not that I'm not going to consider, but the affidavit you submitted doesn't provide any analysis. It provides some conclusions that he believes that you need to have majority minority districts. That's the conclusion. I get that, but there's no analysis. There's no statistical analysis. There's no regression analysis. There's no demographic analysis. There's no analysis of particular races, elections in the past, so forth. What the types of things we would expect to see in these types of cases. There's none of that in the affidavit that you've submitted.
Well, Justice, I say to you, I think if you look at the numbers, just numbers laid out in the primary numbers and the general election numbers, I don't think you need an expert. That's why we put so many samples in our briefing to establish that. But we would absolutely welcome additional time if that would aid the Supreme Court in looking at more detailed analysis from the plaintiffs. We would definitely be happy to do that.
All right. Thank you, counsel.
Thank you.
Justice Bernstein.
Good morning, counsel. And first off, and it's a pleasure to have you here at the Supreme Court. I'm going to ask you a few questions, and we're going to kind of walk through this together. And you probably know my judicial philosophy is I like to keep things simple, and I like to kind of also try to look at things from a human kind of perspective as it pertains to the law that we're kind of deciding here today. So if it's okay, I just want to walk through a few things with you and then kind of go from there. And I want to see if I'm incorrect in anything, I want you to correct me right away.
Yes, sir.
In the state of Michigan, my understanding is that according to the census, that 14% of the state of Michigan would identify themselves as African Americans. Is that correct?
Yes, that's okay. A decrease from 15.2, yes.
Okay, but we're talking about 14%. That would equate to about 1.3 million people, correct?
That is correct.
Okay, so we've got 14%, but you're talking about 1.3 million people. And ultimately, let's just kind of break this down to just, I think, make this kind of understandable. Because sometimes in the law, we can get very complicated, but I think sometimes you just got to go to the heart of it. Ultimately, under the new districts, how many African Americans will be representing the state of Michigan in the United States House of Representatives? Would I be understanding there'd be 0?
0, yes.
So let me just make sure we got that. So you have 14%. 1.3 million people, and in the United States House of Representatives, there will be 0 African-American representation, correct?
That's correct, Justice.
Okay. And under the numbers, there will be 0 African-American representation in the state Senate. Is that correct?
Absolutely correct, Justice.
So basically what you're going to be left with is 7 African-American seats in not the state Senate, not the US House, but in the state House, correct?
That is correct.
You'll be left with 7 seats, correct? Okay. And
That's if they win successfully, yes.
okay, of course. No, I understand that, but we're just doing projections here based off of what you submitted. Now, the next question I'm going to pose is really, looking at this from kind of the crux of the argument that's being put forth. The disability community has a saying that nothing about us without us. This is kind of, the area that I've grown up in is kind of the disability world. So that's just been a saying, nothing about us without us, right? That's kind of how we tend to look at things and how we tend to see things. And I think the crux of your argument and the reason that you're bringing forth this case is that when you're talking about African-American representation, you're talking about the idea that you kind of have to live it to understand it. Is that a fair assessment?
That's very, 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 very fair assessment, Justice.
Right, that there are certain things that are just very specific to the African-American experience, which is basically you don't want people that not everyone understands it unless you have lived it firsthand, unless you know it firsthand, unless it's a part of you firsthand. You don't really relate. You're not able to necessarily understand the complicated issues and challenges and difficulties that exist within that population. Is that fair?
That's very true. Absolutely, Justice.
Okay, so it's analogous to being blind, right? So I'm just going to bring it back to my situation. It's analogous to having a blind person. Basically, as a blind person, there's no one that's going to be able to really explain or understand what it's like to be blind unless they're actually blind. They're not going to get it. They can try to get it. They can try to understand it. They can try to appreciate it. They can try to respect it, but they're simply not going to be able to understand and appreciate it unless they're actually blind. And that is necessary in terms of representation, correct?
Absolutely. Especially if you're white, you've never been discriminated against to a certain extent. You want to know how it is being an African-American. Absolutely.
Okay, and so that's really kind of, in many ways, that we have kind of the essence of it here. And just to kind of give an example, I would imagine, of kind of how this kind of plays out in real life is ultimately this court is having to make a determination or a decision that's going to affect 14% of the state. It's going to affect 1.3 million people. It's going to affect their fate, their representation, every kind of aspect of their life. And I'm just going to kind of pose this question to you, and it's a direct question, but it's the way kind of I tend to see things. And I imagine how the community that you represent sees things. With a court of our nature that's going to be making this decision, that's going to have such an impact on the African-American community and the African-American experience, how many current Michigan Supreme Court justices are African-American?
0.
Thank you, counsel. I have no further questions.
Thank you, Justice.
Justice Clement?
Thank you. Good morning. I just want to circle back to Justice Zara's line of questions on the legal arguments for this case. He asked you about alternative plans, and you said that you submitted alternative plans, but it sounds like you're asking us to start from the existing maps with the majority minority districts and keep those, and then there's not anything presented for the rest of the state as far as the map drawing. Is that where you think the commission should have started? And is that what you're proposing are the alternative maps that you've submitted?
Approximately, yes, Justice. And it's not only where I suggested, I think even with their own experts suggested they should start with. And the rest of the state is not really impacted in a sense outside of the African-American majority community. The Arab American community hasn't been impacted to a certain extent. Other communities we haven't heard have been impacted to a certain extent. It's really the African-American majority. Why not start with those? And there's going to be some little differences and boundaries and what have you, but all in all, you can keep those intact within with a very low amount of work to finalize those.
But isn't it likely that if you keep those intact and then you move outward from those districts, that it's likely that you're gonna have an impact on other communities?
I mean, if 85, 86% are considered white to the rest of the state, I don't think there's going to be much of an impact, considering that the equal population requirements under the Michigan Constitution Amendment, Justice.
Okay, all right, thank you very much.
Thank you.
Justice Kavanaugh.
I just want to follow up on the discussion you had with Justice Bernstein. The answer that there would be no African-American member of Congress representing Michigan would presume that the number of African-American candidates in those races, many of it, would not be elected, right? I mean, your answer is saying there would be 0 members of Congress or 0 members of the state Senate. Presume that those candidates, many of whom are African-American and have indicated or will perhaps indicate that they're running in those districts, that they won't be elected, right? So it may be that they might not get elected, but it may also be that the African-American candidate or I mean, there may be many that they could also get elected though, right?
I mean, also is a big word. Sure, there's always a chance of it, but I think
is it equally as possible that they wouldn't get elected?
Absolutely not. They would not be equally as possible. This is indeed why Brenda Lawrence, we believe, dropped out as the first victim of this redistricting situation. The fact of the matter is the African-American has won by slight margins. If you reduce those majorities of the African-American districts and you look at the voting patterns, it's going to take a miracle for them to possibly succeed at this. And that's what the whole voter dilution protections under Jingles and the Voter Rights Act and this Michigan Constitution is all about, to protect that African-American community, because Congress has realized over hundreds of years that the African-Americans are still not getting their fair shot at of being elected for many different things, as Justice Bernstein mentioned. It could be a whole host of economical and cultural and everything else that comes along with that, health and everything else.
Okay, and one other follow-up, I think, on the questions of Justice Zara and Justice Viviano. The information available, this process, right? This is the first of its kind in Michigan. This process of the Independent Redistricting Commission is very different than prior processes, for drawing districts, right, through the legislature. And part of that is all of the information that the commission used to draw the maps and evaluate and all that is has been publicly available all along. Correct? I mean, typically a plaintiff challenging a map wouldn't have access to, perhaps except through litigation, the data or analysis that the legislature used to draw the maps that they chose, which is different from here, because the commission is required and has been posting every public comment and feedback and proposed maps and all of those sort of things, like thousands of pages of documents and open meetings on. So that information from which to perhaps sustain your claim is publicly available, has been publicly available.
Well, again, I mean, that's their information that your honors, the Supreme Court ordered them to release, and that they're in violation of the Open Meetings Act. And I think they didn't release those.
Well, that was 7 documents. There's thousands of other documents in open meetings, right? I mean, you would agree that there's different information available to any potential plaintiff or challenger to the maps in this process before even filing suit than there was in the previous legislatively drawn process.
I'm not sure, Justice, because I would think that the legislatures, by the way, I think that for over 40 years, they were able to draw these maps, at least without cutting out the African-American majority minority districts to a certain degree. I believe they looked at the U.S. Census Bureau and what they're required to do every 10 years and look at those numbers. And actually that's what the commission was waiting for, and which I think they didn't. That was delayed 6 months by the U.S. Census Bureau on their data. So I think that again, that information, I would think that the bipartisan, either party had information similar to the commission, but yet did not edge out the African American community and dilute their basically districts.
Okay, thank you.
Justice Welch?
Yes, Council, thank you for your time today. I'm just wondering, I think your main argument is that a pre-existing number of majority minority districts should be maintained through the redistricting cycle. I'm wondering, in your opinion, what is the best legal precedent supporting your position for a Section 2 challenge of the Voting Rights Act?
I mean, it's got to be Thornberg versus Jingles, and I think the other side basically cites it a lot. We relied on it. It laid out the framework as to look to see whether there's an actual dilution of the voting in those districts, and I think we've met all of those very strongly, Justice.
Okay, and so if we were to agree with you today, what would we be instructing the Independent Redistricting Commission to do? How should they proceed?
I would ask that, again, we're not asking for the whole state of Michigan redistricting go back and do. We're just asking for those districts. They can just change and amend to those majority minority districts that have been in place for 30, 40 years and just work around those numbers. I think it can easily be done. We've spoken to 2 and 3 experts that basically said that could easily be done within hours or days. So, I mean, send them back to say, draw this to be in compliance with the Voter Rights Act Section 2, and that you don't dilute the African American majority minority districts.
And have those experts evaluated, I believe it was Justice Kavanaugh or Clement, I can't remember who hit on this, have they evaluated the other criteria that the commission is charged with following?
They have. I mean, Mr. Sharpalis has been doing this for 30, 40 years. He's been retained by the Chicago, working currently on right now, on a couple of occasions, currently working with the Chicago to do the redistricting and following, of course, the Voter Rights Act in Section 2 and the mandates of the Jingles.
Okay, and do we know if that has occurred if there is an impact beyond once you sort of play with the Detroit districts, whether that impacts those around them and messes up the other districts they have?
You know, again, Justice Welch, because the great majority, 80-85% is white, is not going to be a lot of impact, at least not in violation. There might be some people that are not completely satisfied, but it's not going to be an impact of a violation of in an illegal sense violating the Voter Rights Act, because again, the great majority is white, and so long as you keep those numbers within the equal numbers of population in those districts, 1 person, 1 vote, they would have no problem in accomplishing that. And we know that they've done it in, they've done it in 2011, they've done it in 2001, they've done it in 1991, and so on and so on, so forth.
Okay, thank you.
Thank you, Mr. Ayad. We've used up all of your time and then some, so let me turn to Ms. McKnight for her presentation.
Does that mean I don't get a rebuttal, Supreme Justice? I'm sorry.
That's what it usually means, but I will, if anybody has questions after Ms. McKnight's argument, we will have time to ask those. But thank you very much.
I'll be here. Thank you, Justice.
Thank you.
Good morning, Your Honors and Counsel. May it please the court. The Voting Rights Act is believed by many to be the noblest, most transformative legislation in American history. It has proved immensely successful at redressing racial discrimination and integrating the voting process. The act requires map drawers to understand racial voting patterns and protect a minority community's opportunity to elect. Where necessary, and only where necessary, this will require drawing majority-minority districts. That is, districts where a racial or language minority makes up over 50% of the voters in that district. But despite our conversation up to this point, and despite plaintiffs' briefs, The Voting Rights Act is not alone. It is balanced by the federal Equal Protection Clause. That clause forbids intentionally assigning citizens to a district on the basis of their race without sufficient justification. It's sometimes referred to as racial gerrymandering. You may have heard that. These two provisions, the Voting Rights Act on one side and the Equal Protection Clause on the other, create two competing hazards of liability. What does that mean? On the one hand, the Voting Rights Act requires map drawers to consider race. On the other hand, the Equal Protection Clause restricts its use and subjects a map drawer, here the commission, to strict scrutiny when it does use race to draw lines. So how does the commission navigate these competing hazards? Very carefully. The seminal case here, which you've already heard about, is Thornberg versus Jingles. It provides 3 threshold requirements or preconditions for drawing majority-minority districts under the VRA. This is a legal threshold. If a plaintiff cannot satisfy these 3 threshold requirements, if a map drawer cannot satisfy these 3 requirements, then no majority-minority district can be drawn without being struck down under a claim under the Equal Protection Clause. Now, the Act does not require the drawing of majority-minority districts wherever they have been drawn before. The Act protects a minority community's opportunity to elect. And what happened is the Voting Rights Act will not step in and require majority-minority districts to be drawn where the minority community in that area has an opportunity to elect its candidates of choice at less than a majority in their districts. And that's precisely what happened in Michigan. The 3 Jingles factors cannot be established because the minority community has an equal opportunity to elect its candidates of choice in districts drawn below majority-minority voting age population, sometimes quite a bit below. As the analysis will show, it's sometimes as low as 30, 36, 35, even 25% minority voting age population. And I'll get to those details in a minute. Nothing plaintiffs have filed shows anything different, right? They have the same information the commission had. They've had the same amount of time to prepare an analysis that counters the commission's analysis. Nothing they've shown or can show counters these points, that all 3 conditions cannot be shown and that the minority community lacks an opportunity to elect its candidates of choice if drawn at districts below majority. These 3 threshold requirements are meaningful. You've already heard a little bit about them. Let me briefly walk through them. I'm going to focus on 1 for this discussion, even though our brief establishes that all 3, none of the plaintiffs have not established any of the 3 in their briefs. The first is that the minority community is sufficiently large and compact to create a district with over 50% minority VAP. The second precondition is that the minority community is politically cohesive. It regularly votes for the same candidates of choice. Number 3, and this is the precondition I will focus on. A white majority votes as a bloc to enable it to usually defeat the minority preferred candidate.
Ms. McKnight, let me interrupt you and just make sure we get through questions. And if we do, then you can go back to focusing on that factor. Justice Zara.
Thank you. Counsel, a very recently decided case out of the Federal District Court in Alabama engages in the same analysis this case tasks us with. And I really couldn't help but notice the sophistication of the expert witness's testimony, including on the threshold factors from Jingles. The same is true of other cases decided by the federal courts. Why do you think this case should be dismissed without having similar testimony presented here? I mean, you're really coming in and just asking us to dismiss it on the pleadings.
Thank you for your questions, Justice Zara. It's a fair one because the Jingles preconditions are a threshold requirement. You do not need factual evidentiary development to prove or disprove those three preconditions. And you're correct, there's a sophisticated analysis that goes into that third precondition of racial block voting. Plaintiffs have had the opportunity to prepare that. I heard plaintiffs' counsel say that he believed he had prepared that and provided it to the court. So this isn't a matter of additional factual development is necessary. This is a legal threshold that plaintiffs will be unable to show and have been unable to show. There are no new facts that plaintiffs need to make their showing. They've had an opportunity to submit an expert report. They chose when to file this suit, when they thought they had enough to establish the three Jingles preconditions. And I think this court will see that it is not enough. What they've put forward is not enough, and there's no additional factual development that will change that.
Well, part of the response was, well, please appoint us an expert. And in as much as this commission has unlimited resources and is charged with drawing legal and fair districts for all the people of Michigan, is this court obligated, or even do we have the discretion to fund an expert for the plaintiff?
I don't think you do, Your Honor. I think these cases...
We don't have the obligation, or we don't have the discretion?
Well, first of all, I don't believe you have the obligation. And as far as discretion goes, I think you can look to what the commission has already prepared. The commission was created by the Michigan Constitution. The commission took its job very seriously. Plaintiffs have not come forward and said the commission did not hire a Voting Rights Act expert. It did not hire an expert to analyze the racially polarized voting. Plaintiffs have come forward and suggested that there may be elections that are exceptions, and I can get to those in a minute, but I don't believe the court has, even if the court did have discretion, it doesn't have, what's before the court is a constitutionally mandated commission that took its responsibility seriously. You don't have a plaintiff saying that it did not engage these experts to prepare this analysis. And so I would suggest to you, Your Honor, that you have everything you're going to need to analyze the merit to plaintiffs' claims.
But if we disagree, do we have the authority to appoint an expert and have the commission fund it?
I'm sorry, Honor, I'm only pausing because the number of Voting Rights Act cases I've seen have not involved, I've never seen that situation arise. I have seen situations arise where you have, after a merit stage, there could be special masters hired, that sort of thing. But I've never seen a court where you have clear direction from the U.S. Supreme Court that plaintiffs bear the burden to come to this court and show that it can satisfy, those plaintiffs can satisfy all three preconditions. I have never seen a court say, you know what, let us take on that burden. It has always been clear that that burden rests with plaintiffs.
But that's not an answer to the question. What you're saying is you don't need to appoint an expert here because you've got everything you need. But if we disagree, do we have the authority to appoint an expert for the plaintiff at the commission's expense?
We don't believe the court has authority to do that, Your Honor. But I would, if you'd like some briefing on this issue, we can look at it further, but that was not an issue that came up in our briefing. I don't believe you have the discretion to do that. I think the court has the expert reports that it can expect to get in this case, and that's the end of the story.
So our hands are tied by the provision that simply says the commission must do the work?
No, I would think, Your Honor, if you had a plaintiff come before you and say the commission needed to do this work, it needed to take its job seriously, and you had a commission that came in with, say, the analysis that plaintiffs came in with, I think you could say that's not up to snuff. That's not doing the job. We cannot order majority minority districts based on what plaintiffs have put forward. So I think there is room for this court to step in and say the commission has not done its job. But there are no claims here that the commission has not done its job as far as analyzing this issue.
Counselor, you're doing a great job of holding firm. I appreciate that. One final thing, in as much as your position is they haven't given you what you need to go further, what impact, if any, should we give to the fact that the commission started its work after the deadline, slowing down the whole process? I mean, there is a date by which these elections have to be held and ballots have to be printed and districts have to be drawn so candidates can decide. So all the extra time that comes at the front end reduces the amount of time for a challenge. So what impact, if any, do we give to the fact that the commission started after the constitutional deadline for beginning its work?
Well, first, I think you know that the commission was hampered, like all map drawers around this country, by the delay of the census data. I don't think anyone doubts the commission's commitment to a transparent and thorough process. The number of open meetings and the amount of materials online is testament to the commission's commitment to transparency and a thorough process. Something plaintiff's counsel mentioned in his presentation is useful here. He said, census data was released in August and Dr. Hanley prepared and discussed a report September 2nd. Your Honor, that's a matter of weeks. It does not, these analyses are sophisticated and take time and attention, but we're not talking about a timeline of months. That kind of analysis can be done and completed in a matter of weeks, in a month. It hasn't been done. Plaintiffs have had the same information that Dr. Hanley had since August.
I appreciate your answer. I would just respond, it can be done when you have unlimited resources, but you have unlimited resources, nobody else does. Enough, I'll pass to the rest of my colleagues. Thank you very much.
Justice Viviana?
Yeah, I'd like to follow up on that. It seems to me, I mean, first of all, these are all mixed questions of law and fact. Is that right?
Your Honor, I'm only pausing because I see where you're going with this, right? Obviously, it's a legal threshold, and facts must
Well,
be.
let me ask you then. Are you arguing that the pleadings are insufficient and we should dismiss the case as a matter of law based on the pleadings alone, or are you arguing that the evidence that plaintiffs have submitted is insufficient and we should dismiss the case as a matter of law because there are no genuine issues of material fact, something that you may be familiar with, more familiar as a Rule 56 summary judgment? Where are we? What's the procedural posture of the case?
Correct. Bear with me, Your Honor. I don't mean to hedge, but in candor, it's a little bit of both. You have a clear legal requirement. Jingles, you can count how many times it's been cited on Westlaw. There is a clear legal requirement to prove a threshold, to establish a threshold. Plaintiffs cannot do it, right? So
when you say to prove, that means facts. Okay, so when you say that, you're acknowledging that this is your argument, I think at this point, is that the plaintiffs have not provided sufficient facts, evidence to support their claims. There's law out there, I think, from a number of courts that say that it's particularly inappropriate to foreclose at the pleading stage plaintiffs' opportunity to prove their claims. Is this something that happens? Let me ask you this. Are there any precedents for a court dismissing a case like this, within a week or two of the complaint being filed, based only on the pleadings? Do you have any cases where that show that that's appropriate?
I have seen cases, and to give you some reference, a lot of these cases are brought on very expedited timeframes because they're impending elections. So there are a number of cases where you have courts coming in on, say, a preliminary injunction, where the court marshals the facts, looks at them quickly, and determines. We do have cases that say.
Let me jump in. So preliminary injunction and marshaling facts, that all sounds to me as a former trial judge like holding a hearing and allowing the parties to present evidence. Is that what commonly happens in these cases? There's some form of an evidentiary hearing?
Well, it's not, how do I say this? We are in a position where courts have this, Jingles is a threshold requirement, right? And the reason I keep saying threshold is you don't even get to the Senate factors or totality of circumstances. You don't even get there unless you satisfy the 3 Jingles preconditions. So I do hear you about facts at issue in that Jingles precondition 3. I'm only pressing back because this is not like a typical case where you need to have factual development on all factors to understand a claim. If plaintiffs fail any one of those 3 preconditions, you don't get into any other facts in this case.
Okay, so should we allow or have a hearing and allow a master to determine whether they've satisfied the 3 Jingles preconditions? And then we can determine then whether the case should go forward?
Your Honor, we don't think that's necessary based on the record before you.
Let me ask this question. It's sort of a variation of what Justice Zara asked. You said at some point that the plaintiffs have had the same amount of time that your clients have had to do their expert analysis, but really, did you expect them to do their expert analysis before they knew they were aggrieved? In other words, were they supposed to hire experts and do the analysis anticipating that you would draw the districts the way the commission announced a few weeks ago that they were going to draw the districts?
Sure.
Why would anybody do that?
Oh, I'll tell you, it happens all the time. And here's how it happens. You have in redistricting, right? There are plenty of plaintiffs out there watching what's going to happen in redistricting. And when you hear, as a plaintiff, when you hear that a redistricting authority has conducted an analysis and has determined that majority minority districts are not necessary because there is sufficient white block voting, there's sufficient white crossover voting to support minority candidates. That's what happened here. As soon as you hear that, and if you truly believe, I think there's a claim here. I think we're entitled to majority minority districts. That's when you start your work. And candidly, you see work started even earlier than that. In redistricting all over the country right now, you have plenty of, it's not just individual plaintiffs, there are plenty of interest groups out there submitting letters and submissions to commissions saying, look, we need majority minority districts. This is why. They're submitting evidence to map drawers all over the country. That happens. So I hear your concern about this notion of, well, they haven't, they didn't necessarily have, their claim hadn't become ripe yet. But it happens all over the country with redistricting that before maps are passed, you have people coming in saying, we heard you say majority minority districts aren't necessary. We believe they are. Here's the evidence. So
no, it makes some bit of sense. And you're certainly more familiar with redistricting litigation than we are. But I guess one question remains in my mind. Some of these cases from other states involving maps for the coming election have already been resolved, as Justice Zara alluded to. That must mean that those maps were published earlier than ours. And assuming that to be the case, since the litigation over those maps has already concluded, or at least at the trial level, are we in a unique circumstance here where we're have even less time than almost every other jurisdiction, and we've already noted there's already been some discussion of the resource imbalance under the particular circumstances of this case? Is it reasonable for us to appoint an expert to do some of this work, to report back to us in an expedited fashion so we can make the Jingles precondition determination? Would that be a reasonable way for us to proceed?
Well, Your Honor, a couple of responses to that. The first is that the state has hired an expert. It hired 2 experts. It hired Dr. Lisa Handley, who
with due respect, the state, and actually I don't think is a party to the case, the commission is, and the commission, in my view, is only a party to the case. It's not a favored status litigant that comes in here with additional weight on its side. It has to sustain its burden under the law, just like any other litigant that comes before the court. I mean, isn't that how we should approach this case? Or should we say that your client has sort of a glow about it so that anything it says we have to accept as true? I mean, that's not again, as a former trial judge, I've never really heard of a case proceeding in that fashion. We don't have favored status or courts that are partial to certain litigants, do we?
Your Honor, of course, the commission does not have a glow. What the commission does have is a majority of the voters in Michigan said this is how we want maps to be redrawn, and developed a clear process in the Constitution for how the commission should do its work. There's no claim here that the commission has somehow balked at its responsibilities, has not fulfilled those responsibilities.
That's not what we're talking about now. The question is whether the commission's representations and submissions to this court somehow carry more weight than any other litigants. I think you just agreed with me that they don't. They should be accorded the same weight as any other litigant's submission to the court. At least I think that's what your position would be. But let me move on because yeah, go ahead.
If I may, this really comes down to the burden of proof here. The burden is on plaintiffs. I do conduct Voting Rights Act litigation across the country. I see a lot of resources put toward plaintiffs' case. I don't know why we're not seeing that level of resources here, right? But this is where we are. Plaintiffs decided when to file their case. They've filed with you what they think satisfies the 3 Jingles preconditions. I think it's clear from our briefing and from our own analysis that it does not. I hear you ask about does the commission expect special treatment? It does not, but it asks the court to focus on who holds the burden here to satisfy these threshold requirements. Has it been satisfied? There is no requirement that the court satisfy plaintiff's case for plaintiff. Plaintiff has had an opportunity to put that before the court. We can't speak to the resources at issue here, but we can tell you that what the court has before it is enough to decide the threshold issues and enough to decide it in favor of the commission.
Let me just ask one last question because I don't want to monopolize your time any more than I already have, but this sort of goes more to the merits. Your expert has said, and I'm quoting, that districts of 35% Black voting age population or more are likely to afford members of the Black community an equal electoral opportunity given white crossover voting levels. In other words, she does not think that a 50% Black voter voting age population district is required for Black preferred candidates to win in a general election. Does that hold true for primaries as well, or is that only for general elections?
So Dr. Handley looked at over 100 elections, primary and general. I think it's detailed in our brief, pages 11 through 14. We give a summary of her findings, but it holds. She has analyzed all those elections and built them into her conclusions that she makes. And by the way, it's page 11 through 14 in our brief, but of course we also attach her analysis in the appendix. And I might say there really is a danger in following plaintiff's path here.
Let me just, I don't want to interrupt, but we're going to run out of time. Does it apply to primaries? It may be what you said in your brief and I just haven't seen it. Does that statement cover primaries?
Yes, she's looked at primaries and this is her conclusion based on the analysis of all those elections.
Let me just ask one last question, which is, these are all, I guess, predictions about future outcomes. What if these predictions do not turn out to be true in the future? In other words, what if no Black candidates are elected other than in the half dozen or so House districts that are majority minority? Would the plaintiffs be able to or be entitled to relief at some point in the future if they were to bring a claim under that scenario? What if your predictions don't turn out to be true?
It's a great question. And that would be an example of where there is factual development that plaintiffs could come in and make this claim to this court and say, look, we've tried this, it's not working. But I need to quibble a little bit with what you said, which is you said, if there are no Black representatives elected, and what the Voting Rights Act protects is Black preferred candidates here. And that is not always a Black candidate. Often it is, but it's not always. And that's the kind of careful, sophisticated analysis that needs to be done and was done by Dr. Handley.
Your point's well taken. I mean, you do make reference in your brief on page 11 over to 12 that white and black voters tending to prefer different candidates. But I understand your point. I appreciate your responses to my questions, and I yield back to my colleagues and apologize for taking up so much time.
Justice Bernstein.
Hi, Council. Good morning. First off, I want to say you're doing an excellent job. I mean, you've been fielding a lot of questions, and I just want to say you're doing a wonderful job. I have really just one question. I wasn't going to ask any, but I do have one that kind of arose out of your discussion with Justice Viviano, and it concerns me a little bit. So I'd like you to kind of do your best to answer it. You said that, you had done, work in all these different voting rights cases, and in all those different areas, you've seen tremendous resources being put into those cases. But then you went on to say that, you don't see that here. You don't see the level of resource that's being put into it in this specific case in what we're discussing here today. So it goes back to kind of a resource question, which is, my concern is, and I just want you to kind of help clarify it. My concern here is based off of your comment that, well, you've seen all these resources getting poured into all these other cases, but you haven't seen resources getting put into this case, leads me to be a little concerned, because it seems to me that you're arguing on the basis of not what necessarily is the right disposition, but on how the case is being presented. And the reason that I'm concerned about that is that if you could just address my concern that, based off of the resource question that you were asked by Justice Zara and Justice Viviano, based off of this resource issue that we've now gotten into, my concern is that your argument seems to be that it's a might makes right kind of argument. And I'd like you to assuage my concern on this might makes right, that this is all going to come down to resource.
Right. Well, thank you for that question. I do really appreciate it, because I meant no disrespect to any effort that has been done in this case. And my point was really rooted in a point that plaintiff's counsel made about needing time and additional resources if it could. And really what I heard from plaintiff's counsel is that they think what they have is enough, but if the court was willing to give more time, it would use it. Might certainly does not make right in these cases. I could give you plenty of examples of pro se litigants with successful Voting Rights Act cases. And it's really heartening and compelling to see the Voting Rights Act brought forward by pro se plaintiffs with far fewer resources than any of plaintiffs' counsel here have, and they've been successful. So I beg your pardon if anything I said suggested anything other than that. Plaintiffs can certainly come in, a pro se plaintiff could come in with a successful Voting Rights Act case. They can't do that here. And the reason is they don't have the analysis. They don't have the analysis to show that there is not, that there is a white bloc voting, right? So
it seems a little bit of a contradiction, because you're saying that a person could come in and do this pro se, but then you're saying, but then they have to have all this analysis and expert analysis. It seems a little bit of a contradiction.
I see. What tends to happen is you see interest groups coming in and supporting the pro se effort and putting forward an expert report, which plaintiffs are represented by counsel here. They knew the need to put forward an expert report, and they did.
Okay. Counsel, thank you so much.
And Justice Bernstein,
yes.
If I might respond to a question that you asked of Counsel Ayad, is that appropriate here?
Please, absolutely.
Okay, I heard you ask him a number of questions about number of majority minority districts, and you marched through Congress, Senate, and the House. And I think it's very important here that just because a district is not drawn at majority minority does not mean it will not elect a candidate of choice for the minority community. And so I would refer you to pages 14, it starts at page 14 through 16 of our brief. Now, there's a chart that's just focused on the counties at issue in this case, but it is a chart that looks at the minority voting age population in congressional districts, Senate districts, and House districts in the counties at issue here. And what you'll see is that there are a number of districts. The number is not 0 in Congress. The number is not 0 in the Senate. There are a number of districts where the minority community is afforded an opportunity to elect its candidate of choice, even though the minority VAP, voting age population, is lower than majority. And the danger in following plaintiff's path here is that you consolidate minority voting power in fewer districts. So if you truly are concerned about the number of districts where a minority candidate, preferred candidate, can be elected, you have to commit to the analysis that Dr. Handley did, and the charts that we have at 14, 15, 16 show that the minority community has greater influence in more districts in the enacted plan than if you go with plaintiff's route.
So, but counsel, I have a follow-up question to that. And first off, thank you so much for that clarification. I think that's very, very helpful. But then I just want to kind of follow up to the answer that you gave to Justice Viviano, which was, if that doesn't happen, then the plaintiffs can come back. And doesn't that create a more difficult situation?
No, and that's a great question. That happens regularly in these cases. Plaintiffs are entitled, and some plaintiffs do wait to see what happens in an election, maybe 2 elections. And they come to the court and they say, look, you passed this and you thought it would perform, and we can show you that it's not performing. Plaintiffs will be entitled to do that if those are the facts that are present at the time.
Okay, counsel, thank you so much. I defer to my other colleagues.
Justice Clement.
Thank you. No questions.
Justice Kavanaugh.
I have a question on process. I mean, I think everybody is committed to making sure that we've, that there's enough process, the proper process to decide these cases. And we are in uncharted territory, right? As far as our authority, we don't normally sit in as sort of trial court judges or court of original jurisdiction. And so it is, we're figuring this out too, I guess you could say, and we want to make sure that we're doing it correctly, right? So I wanted to ask you, I think you, in response to something that Justice Viviano asked you, you said, it's a bit of both, right? And tell me if you have a different way of looking at this, that, if it were in state court, a C8 or a C7 motion, say, or in federal court, a 12B6 motion, something like that, that the plaintiff files a complaint and a first responsive pleading says, I'll take everything plaintiff says as true, and they don't state a legal claim upon which we can grant relief. And as opposed to perhaps at the end of discovery or after some discovery, as a C10 or a Rule 56 motion that says, here's what the facts are. They haven't established a genuine issue of material fact. And this is a bit of a hybrid, right? Because it's not like plaintiffs have just filed a complaint and entitling them to be able to have a course of discovery to prove the facts in which they're alleging. They filed a brief, a supporting brief, which is not a typical C8 sort of thing. They filed an expert affidavit, and then you filed, or the commission filed a responding brief and a reply. Are we sort of in C8 territory, 12B6? Are we more in Rule 56 or a C10 territory? How should we sort of look at this case as sitting as sort of a court of original jurisdiction on this?
Well, thank you for your question. I think we are in uncharted territory. This commission is new, right? And this is the constitutional provision is new. I will say that we are in a position where we think the court is well positioned to look at the legal requirements in cases. And I do I do appreciate this a little mix of both idea, but the court really is in a position to apply the law. And the law here requires the three preconditions be satisfied. And the court is in a position today. It has plaintiffs. I understood plaintiffs to say the court has from plaintiffs what plaintiffs think it needs to make the decision on the three preconditions. We believe the court is in a position to make a decision on the three preconditions. And so in some way I could envision a situation where the court says, okay, we can make a decision on the three Jingles preconditions and whether plaintiff has met its burden to satisfy those preconditions before we go on, right? And the court at that point can decide, has the plaintiff met the preconditions and we need to move on with further factual development? Or has plaintiff failed to meet those preconditions and the case is dismissed? We think the court is in a position to do that today.
Okay, thank you.
Justice Welch.
I just have a question. You mentioned other cases around the country, where plaintiffs have prevailed in these cases. I'm just curious, what in your opinion was a big differentiating factor between this case and those cases?
Well, let me, as an illustration, let me use the Alabama case that was mentioned by another justice. In that case, you saw, I think there were no elections analyzed where the minority preferred candidate was winning, right? You had expert reports in that case showing exactly the opposite of the issues that you have in Michigan, right? And so you have cases in other parts of the country, and some of them are very expedited. And I believe Alabama was on a preliminary injunction at that sort of posture. But what can be gleaned from those other cases is that a court is capable of looking at the legal threshold requirements of Jingles without a trial, for example, and determining have plaintiffs met their burden? Have they put forward in expert reports or in briefing a showing that they satisfy these three preconditions? That can be done without a trial, without further factual development. And so I think when your question comes to other cases and how they're working, if you can bear with me, the Alabama case is another great example of the Voting Rights Act is meant to protect opportunity to elect, right? And what the Alabama court found was that's not happening down here. And when you turn to Michigan, what you are seeing is a level of integration that should make Michiganders proud, candidly. The great hope of the Voting Rights Act is that there will come a day when it is no longer necessary to draw majority-minority districts in order for minority communities to elect their candidates of choice. And Michigan is seeing some of that progress already, and you can look to Dr. Handley's analysis for support on that point. I'm sorry I went a little bit afield, Justice Welch. I want to make sure I answered your question as far as what other cases are doing, but I thought Alabama provided a good illustration.
All right, no, thank you. That does it. Thank you, I appreciate it.
Ms. McKnight, we have also used up all of your time and then some. Thank you very much for all of your answers to all of the questions. I'm going to see if any of my colleagues have any follow-up questions for Mr. Ayad, because a lot has been going on. If anybody does, now would be the time to ask those.
All right, I'll bite and just give you a chance to respond to some of this. What's your response on the resource issue?
Yeah. Thank you, Justice. Very much appreciated. First of all, Metz versus Murphy, First Circuit here, court, March 2004, said that the court should allow continued hearings entitled to develop the evidence, and deciding the Jingles preconditions on an MSD was premature. That was in 2004. But the fact of the matter is, we need, opposing assumes that I'm sitting around waiting for the districting out of all my cases to say whether we're going to bring suit against this man. I mean, we're attorneys. We need plaintiffs. We need plaintiffs. Plaintiffs have to approach you. They have to talk to other plaintiffs. The decision was on December 28th is when they made the final redistricting maps in place. Immediately, I was contacted 3 days later. I was working on New Year's Day. My team of attorneys, me, 2 other attorneys, working around on consulting with other attorneys and other groups and what have, working around the clock to get these in. Not one person has been paid. In fact, not the expert, not the attorneys, nobody has the resources. In fact, I paid just for somebody doing some legwork $300 the other day, but no one's being paid. And it's really, we had to kind of, the argument then, why did you bring the lawsuit? Well, we brought the lawsuit because April 19th is the application starts getting in, and people know, we need to know where they're going to be living, what's their constituents, what's their district. There's not a lot of time. And again, maybe it's because of the lack of the Census Bureau bringing this information in the 6 months delay. But again, why should this community be the sacrificial lamb in all of this? It's unfair and it's unjust. So I say that. Second, I say, you know, and if we were talking about MSDs and why, and on the pleadings, as your Honor, as your Justice clearly know, you must take this as true. If they want to develop and we want to move for MSD on the matter, that has to come after evidence has been submitted and taken, what have you. We submitted this because of the uniqueness of this case. We submitted a brief, an affidavit, and submitted it in the time situation. That doesn't mean we waived our right by any means to forego discovery or additional information. Obviously, this court needs to be equipped to make a final decision. I think your honors are supposed to take this as true on the facts as stated. Opposing counsel wants you to disregard that census. Opposing counsel wants you to disregard a lot of stuff. They didn't even want you even mingling with what is a community of interest. If you look at their briefs, they didn't want you to, they said they want to put a chilling effect on, oh, if you touch this now, it would be a violation of the equal protection, be subject to scrutiny. They're trying to put this chilling effect. In all essence, this is exactly what the Supreme Court is there for. It's exactly what the Constitution and the voters of the state said is for you to oversee the redistribution. Make sure that doesn't violate any state and federal rules. That is what the justices are here for. That's all I have to say, Justice. Thank you.
Thank you, Mr. Ayad. Thank you, Ms. McKnight. That concludes the argument. The case will be submitted. Thank you very much.
Thank you.
Thank you.